constitutional amendment in California. Although California's constitution provides that it can be amended, the Constitution does not define this term. Of course, a traditional definition of a constitutional amendment is some sort of modification or change to an existing constitution. California's Office of Legislative Counsel defines a constitutional amendment as a resolution proposing a change to the California Constitution. It may be presented by the legislature or by initiative, and it's adopted upon voter approval at a statewide election. In California, there's a legal distinction between amending the Constitution and revising it. However, as you might expect, there isn't a definition in the Constitution of California to distinguish between these two types of modifications, but the courts have defined the difference for us. Article 18 of the California Constitution also sets forth amending and revising the Constitution. In Section 1, the legislature is granted the ability to propose either an amendment or a revision to the Constitution. Both a proposed amendment and a revision requires a vote of the people. If the revision is requested by the legislature and the voters approve it, then a constitutional convention must convene. In Section 3 of Article 18, the people are only allowed to amend the Constitution and not to revise it. So for constitutional amendments in California, there are two methods, proposed by the legislature and proposed by the people. Let's look at each one. For constitutional amendments proposed by the legislature, they're mentioned just once in Article 4, Section 8.5, which includes a provision for a constitutional amendment proposed by the legislature. Again, the term constitutional amendment is not defined anywhere in the state constitution. Later in Article 18, Section 1, it says the legislature by roll call vote entered in the journal 2/3 of the membership of each house concurring may propose an amendment or revision of the Constitution, and in the same manner may amend or withdraw its proposal. Each amendment shall be so prepared and submitted that it can be voted on separately. As a result, the legislature can and does propose amendments to the California Constitution, so long as both the Assembly and the Senate vote by a 2/3 vote in each house to place that measure on the statewide ballot. Note here that the governor does not have a formal role in the adoption of proposed amendments. In other words, once a proposed constitutional amendment, an ACA, Assembly Constitutional Amendment, or SCA, a Senate Constitutional Amendment, does not go to the governor for signature or veto. Of course, that constitutional amendment is subject to a majority vote approval of the people at the next scheduled statewide election. So how about constitutional amendments by the people? For those, the process is set forth in Article 2, dealing with voting and direct democracy, specifically Section 8 of Article 2, which provides that first, the initiative is the power of the electors to propose statutes and amendments to the Constitution and to adopt or reject them. Secondly, an initiative measure may be proposed by presenting to the Secretary of State a petition that sets forth the text of the proposed statute or amendment to the Constitution and is certified to have been signed by electors equal in number to 5% in the case of a statute and 8% in the case of an amendment to the Constitution of the votes for all candidates for governor at the last gubernatorial election. So, as a result of these constitutional provisions, the state's electorate can propose and adopt amendments to the California Constitution without approval by the legislature or governor. Just like with amendments proposed by the legislature, those proposed by the people through the initiative are subject to majority vote approval of that electorate for adoption.